Mr. Hanuman asks, sir,
Mm,
that he is a flat owner
mm.
and he purchased the flat in 2013. Now, Colony Association president demands
I have read
layout
it.
development.
I
Yes.
have read it. The question is, Colony Association president, new president has asked, sent a letter to pay the development charges, and he said in default he gave a letter to the sub registrar who stopped registrations. What shall I do? This is the question, right?
Yes, sir.
So, so far as, and there is also an LRS, somebody has asked a question relating to the LRS. It's like this. First, we do not know from the queryist whether he has got all the permissions, include whether it is a sanctioned layout or an unauthorized layout. The development charges, whether they are the question of development charges being paid at this stage does not arise unless the if no permission for construction would be granted by the local authority unless there is an LRS for that particular plot. There need not be LRS for the entire colony, entire layout, unauthorized layout. The rules have given an option even for a single plot purchaser in an unauthorized layout to get it regularized so far as his plot is concerned, in which case his liability is discharged. But if the others have not been paid it and the layout level is association is created and that association wants to do it, pay it, and again collect from this particular plot flat owners, it may not be correct if this particular plot was regularized under the LRS. These people have to check the permissions they have obtained, whether there is a permission at all for construction of the apartments, or the construction itself is illegal without any permission. Or normally, there is no possibility of a plot, a permission being granted in respect of a plot in an unauthorized layout unless LRS is obtained. Let him check both these things. So far as LRS is concerned, the Municipalities Act, Corporation Act, and the HMDA Act are amended to provide for regularization. What is regularization? Regularization means something which is either a layout or a development or the construction which was made without the necessary permission, which is unauthorized, which under the act is liable to be demolished. But the governments, out for the sake of revenue, have made it a policy every time to regularize what is unauthorized. The things have come to such a stage. If you go for construction, permission for construction, or the service connection for a water supply or the drainage, sewerage, it is very difficult. But you can manage the officials, make the construction, and then go for regularization. It is easy. It's very unfortunate state of affairs, but it is happening in the town planning. And what is the other question, ma'am? Next question.
Next question is from Mr. Shyam. He's saying he's a prospective flat buyer and understands that he need to buy a flat only with RERA registered properties. He need to buy RERA registered property.
There,
But what are the top three things that he
yes,
needs to
he said
be
what are
careful
the
about?
three main things. Regarding the three main things, number one, you have to check the title yourself. It's a checking a title is a very complicated thing. It is not a clerical work where you can see the checklist 1, 2, 3, 4. Therefore, the title is there. It involves a lot of understanding of the laws and the land records. So, and there may be litigations. You will have to understand in such case the decrees that are passed. People try to tell everybody there is a court order. The court order doesn't give any title. It binds only the parties. Therefore, title, you will have to see so many things, and you will have to necessarily go to a experienced lawyer and get it checked. So far as the title, that's the first thing you will have to check. Then you will have to check all the permissions, whether all permissions, whether it is in the residential zone, if it is a flat, whether it's a commercial zone, if it is a commercial flat or an office, and whether all the permissions are obtained, service connections are obtained, no objection certificates are obtained. All these things you will have to check. And now, third thing is RERA. If the RERA, first thing is, if it is, we have just now seen when the RERA applies, it is a real estate, it must be a plot or a flat or a villa or a building within the real estate project. That real estate project should be within the planning area. And if it is a flat, it should be more than 8 or more than 500 square meters, in which case RERA applies. In such case, you will have to first verify whether there is a RERA registration, then go to the RERA authority and verify whether the information that is provided there is complete or not. If it is incomplete, file a complaint to the RERA authority, in which case they have several powers to give directions or even cancel the registration in default. And therefore, in fact, in the Hyderabad, in Telangana RERA website, I have seen many things are not being uploaded. Most of them are incomplete, misleading also. They don't show what is necessary. That means they are not there. Whatever is missing, you will have to get it checked at least by an advocate. And if you find that whatever are prescribed under the rules and the Act section 4 and 11, there is a enumeration of list. You will have to cross check. If all those things are not there, then insist for them or complain to the RERA. Unless all that information is there, don't buy. So far as the permissions are concerned, they will have to upload all those permissions. You can put your queries also to the builder, and if the queries are not answered, it is his duty to disclose the information. You can give a complaint to the RERA authority. This is one thing I would cover from here itself regarding the consumer. There are three now. There are three remedies available to the allottees, which I wanted to cover in my the talk itself. Why I'm saying is, when you have certain rights, you know that you have right to information, right to disclosure, right to get queries answered. Right, this is your right to information is most important right, which is protected under RERA. And you can go to the RERA authority if it is during the construction, because RERA authority is one who has a lot of powers until occupancy certificate is issued. Therefore, if it is an issue, anything, go to the RERA authority and complain. If the RERA authority doesn't take action, immediate action, you will have to file a writ petition against the RERA authority. And second, if it is if in case of a delay or default or deficiency of service, and you will become a consumer, and then you better go to the consumer court, consumer fora. At the district level, there is the state level, there are the state commission is there, district forum at the district level. You will have to approach them. And if the promoter is a company and the company is facing insolvency, in such case, they have amended the IBC, Insolvency and Bankruptcy Code, by an ordinance in 2017, followed by the First Amendment Act of 2018, where by amending Section 7, an LRT under RERA, an LRT under RERA is deemed to be a financial creditor of the project of the. So therefore, he has right to file an application for insolvency process and entitled to be represented in the committee of creditors and also seek dissolution, liquidation. So these powers are given. Whether the question is whether he is a secured creditor or not, there are so many controversies. No, there is no judgment. But my personal opinion is, in view of the section 4 and 11, in which the mortgage, any mortgage, the developer or promoter has a right to obtain loan, project loan. He can mortgage. But if he makes the first sale, then he is not he is liable to discharge that loan to the bank, and the mortgage is not that mortgage is not binding on any of the purchasers or allottees. That is the most important thing we have to note. When you are an allottee under the RERA Act, and under the RERA Act, you have that right. That right is preemptive right over the bank, which has got the mortgage rights. Bank has no whatever secured. It may be a financial creditor, secured financial creditor, but under the RERA Act, the preeminent right is given to the allottee, and it is void against the allottee. Therefore, in my opinion, he is a secured creditor, so far, even under the IBC, and he will have better rights in any scheme or any insolvency resolution that takes place. That is my opinion. So you will have to choose depending upon the circumstances. Next question, madam.
Yes, sir. The RERA ensures that there is transparency in land ownership of built apartments. But after MRO and BRO gives the clean check, after 20 years living in these dwellings, the government starts claiming it is a government property or endowment property. What's the plight of middle class man?
See, we have already discussed about this. So far as the title to land is concerned, if the government of India or its established its public sector undertaking, insurance companies, LIC and its subsidiaries have provided for this kind of title registration, this problem would have been solved forever. Title registration is mandated, it's compulsory under section 16. But there is no product being offered by any insurance company in India, and they don't have those skills also. And the government of India should have insisted for the insurance companies, or somebody has to approach file a writ petition against the insurance regulatory authority also. And so I am told that this application is kept deliberately pending before the insurance regulatory authority, and because unless that product is cleared by the insurance regulatory authority, it cannot be done. So some NGO has to approach the court for clearing this. If what is the importance of this the insurance is, if the title registration is done, then number one, you will straight away get the compensation if there is any defect. That's a very great relief. And number two, the insurance companies would not give the premium at all, insurance premium at all, insurance policy at all, unless they are satisfied about the title. So they know the risk involved. It's a great risk. In which case, the insurance companies would take care of the entire scrutiny of title, which itself is complicated. And the insurance company will definitely see that these bogus certificates are not acted upon. And one thing is, we can't entirely blame the promoters or the government for this mischief. The buyers are also contributory in this particular negligence. Wherever if you get any flat or plot for a cheaper rate than the market value, it goes without saying that the title is defective. Who will sell below the price? But people are greedy. People know it. It's not as if they are so innocent. But the moment the problem comes, they will make hue and cry. So this kind of, and if there is any defect, even a slight defect, the premium will go up if there is an insurance. So people should fight for this right under section 16 for compulsory insurance for the title registration. That will take care for all these problems and malpractices in this real estate sector. Next question, ma'am.
Yes, sir. Next question is, what is the impact of GO 111 lifted?
GO 111 is outside our subject, but anyway, you have asked. It is actually GO 111 is a GO issued by the government for the purpose of protecting the feeder channels, the what do you call that catchment area of the water bodies called Hussain Sagar and Himayat Sagar. Not Hussain Sagar, Himayat Sagar and that Usman Sagar. Both are situated in Rangareddy district, which were the source of water for the city. And the governments are looking at more at real estate today. Money takes, I think people also think that money is everything more than life. There is some article like 21. Article 21 of the Constitution guarantees right to life to everyone. And there is another article 54A, which makes a fundamental duty of every citizen, whether in power or out of power, to protect the environment. And the environmental law has been greatly developed in the recent years. And green tribunals are constituted under an act after the Supreme Court gave direction. And the High Courts, Green Tribunal, Supreme Court, all will protect these environmental ecology. It is their duty to protect the ecology. It is now set in law. In fact, that Dr. M.V. Naidu case relating to the area covered by GO 111 itself emphasizes the importance of the ecology. It is part of the right to life of everybody that ecology must be protected because we are part of the ecology. And the ecosystem, the significance of water bodies is not limited to only drinking water facility, which as the governments are trying to picturize for real estate purposes. The catchment area, water body has to be protected at any cost. Water body is part of the ecosystem. Water body is necessary not only to provide drinking water, but also it acts as a percolating source for groundwater. It also is a coolant for the environment. Already we are suffering from lot of what do you call the global warming on account of so many, and on account of the high carbon content, a lot of radiation. All this to some extent will be cooled by the water body. So water bodies have, it is the duty of the courts to protect. So it is not, I don't think even the state legislature, this is maybe an executive order, 111, can really interfere in the matters of environment in the context of Article 21 as developed, as been exposed by the Supreme Court in various judgments. So the state government decision to revoke 111 and appoint a committee of experts in what manner this area should be reutilized by another scheme, that we should permit construction in a limited manner. We will develop big, very big green areas in other areas. These are not, number one, practical. Lot of politicking. The moment this kind of one area is allowed to be in the green zone, one area allowed to be construction zone, it will start, lot of litigation will start. It's not so easy. But anyway, this is a Pandora box which is sought to be opened, and realtors are too happy to do their business and make a fast buck. But the buyers must be careful, and they should not repent if the in future litigation courts interfere even after 20 years, 30 years, then you will have to blame yourself and not the government. What next, madam?
Mr. Vishnu asks, one of my friends booked a plot with Country Club in 2014. Some offer scheme where they promise annual resort gym facilities by paying 2 lakh rupees, and they did not register the plot till now. Now he wants to get back that money. What should he do?
One thing is, so far as the context of RERA, when did he book, madam?
2014 with Country Club.
So definitely it is pre-RERA regime. Therefore, he has to approach either the civil court, competent civil court, or the consumer fora under the Consumer Act.
Okay. There's a big question here by Mr. Sudarshan again. Sir, I bought 600 squares from a developer called name as Vikyat Developers, Hyderabad, on installment basis, and got the document of registration in 2016. I paid for LRS at rupees 10,000 per plot of 200 squares for a total amount of rupees 30,000 and rupees 10,000 for development charges. I have received
600 squares you initially said?
Yes, yes.
Now you are saying 200. Is it different, separate?
Per plot of 200, no, it's same. I paid for LRS at rupees 10,000 per plot of rupees 2,000 squares. Per plot of 2,000 squares for a total amount. In total, he bought 600 squares from a developer, and per plot of 200 squares for 10,000. He has paid development charges. He has received issued by the developer. No LRS received. Now the lands are to be taken over by TRS government for Kaleshwaram projects. Please advise us the action to be taken by the buyers of 6 villages. The total area of lands to be encroached is 1,000 acres. Mr. Sudarshan, if you want to ask your question live, you can raise your hand and we can allow you and ask your questions live from sir.
This summary, what can I understand from this is, he has obtained a layout, the plot in an unauthorized layout, and then paid the LRS. Whether the LRS was granted or not is not known. Whatever it is, whether with or without LRS, he is the owner with the defective title, with reference to the land use only, because you can't use it for construction. Otherwise, you are the owner. Your ownership rights have not gone anywhere. And now you are worried about the acquisition by the government. Acquisition is for a project. The government has a power to acquire the land for a project. That is called public purpose. And so far as the public purpose is concerned, governments have power. You are only entitled for the compensation. But if you still want, you can still prove that this particular land is not either suitable or not necessary for the purpose of the project, then you can collect all that information which you by which you can successfully challenge the acquisition and file a writ petition in the High Court challenging the acquisition. Normally, the courts will not interfere when only a small person having a small extent alone challenges, unless all the persons who are interested in that big chunk of land are interested. So therefore, it is for him to consult an advocate and take steps for challenging. And next.
Yes, sir. So the next question is, Mr. Subbarao Garu, he has appreciated your talk and he wants you to please cover the applicability of RERA Act once again. I heard as 8 apartments or more or 500 square meters land or more. Is my understanding correct?
What is the question about?
He's saying, as usual, you explained in simple language. Can you please go over the applicability of RERA Act once again? I heard as 8 apartments or more or 500 square meters land or more. Is my understanding correct?
Yes.
That's what it is.
See, the definition of the real estate project and the requirements of registration are different. See, it is like this. When it comes to registration, these requirements which are provided under the section 2, which says, notwithstanding anything contained in subsection 1, which mandates the registration, no registration of real estate project shall be required. A, where the land proposed to be developed does not exceed 500 square meters, or the number of apartments proposed to be developed does not exceed 8 inclusive of all phases. That is, does not exceed 500 square meters. That means 500 and below. If 501, it requires registration. 500 and below doesn't. Similarly, exceed does not exceed 8. 8 exceed means 9 and above. Does not exceed 8 means 8 and below doesn't require registration. This is what the Act says. But the question is, this is for the purpose of only the section 3, which is for registration. But it has to be debated that whether this will apply to the provisions in chapter 3 and other provisions where the rights and the liabilities of the apartment owners, by allottees and promoters are laid down, are clearly stipulated. So, in the context of the Supreme Court judgment that all the apartment acts stand repealed because the subject matter is one and the same, we need to go, according to me, the definition of the apartment and real estate project for the purpose of answering this question. So far as the real estate project is concerned, that is defined in section 2 ZN. Real estate project means the development of a building or a building consisting of apartments or converting an existing building or part thereon into the apartments, or the development into plots or apartments as the case may be, for the purpose of selling all or some of the said apartments or plots or building as the case may be, and includes the common areas, development works and all improvements, structures thereon, and all easements, rights and appurtenances belonging thereto. So this real estate definition, real estate project definition does not fix any particular number. It only says it has to be the development and for the sale, for the purpose of selling some or all. And when you see the definition of apartment under section 2E, apartment, whether called a block, chamber, dwelling unit, flat, office, showroom, shop, godown, premises, suite, tenement, unit, or by any other name, means separate and self-contained part of any immovable property, including one or more rooms or enclosed spaces located on one or more floors or any part thereof in a building or in a plot of land used or intended to be used for any residential or commercial use, such as residence, office, shop, showroom, godown, or for carrying out any business, occupation, profession, or trade, or for any other type of use ancillary to the purposes specified. So this does not include, definitely excludes industrial, but any kind of commercial activity, professional activity, or residence, they are covered. Here also there is no prescription of the number or the size of the land in which it is constructed. So taking these definitions, because section 3, the exception, the subsection 2 of section 3 only exempts from the requirements of registration that is mandated under subsection 1 of 3. But for the rest of the act, it is these definitions which are applicable. Not, therefore, the requirement of section 3(1) for registration has no bearing for application of other provisions of the act. That is my view. So my view is that this requirement of minimum 8 plus more than 8 or 5, more than 500 square yards has no application for the purpose of chapter 3, in which rights and liabilities are stipulated, is my opinion. Next question.
So, Ms. Shivani asks, is there a separate code for RERA like a consumer code?
See, yes. The answer is yes. Under the RERA Act, there are two primary authorities. One is the regulatory authority, RERA authority, before whom you can go, you can make any complaint as to the violation or non-compliance by the developer or builder, who is called promoter. The other is the adjudicating authority appointed under the Act under section 71. Who, and this adjudicating authority, the appropriate government will have to appoint for the purpose of section 71, and you can approach that authority for any type of compensation, and both people can also impose can direct refund of amount or any other relief, or for compensation and payment of interest, etc. Under section 71, the adjudicating authority is entitled to give compensation under section 12, under section 14, 18, and 19. That is 12 and 14, non-adherence to the plans, and 40 and the non-adherence to the veracity of advertisement and prospectus and other model house, etc. If your apartment is not as per those what is displayed as disclosed, you are declared, you can go for seek compensation. And under 18, if the possession is not given in time in accordance with the terms of the agreement, or on account of discontinuance of business by the promoter, you are entitled for compensation. In these circumstances, Under section 14, I have already said non-adherence to the plans. These circumstances. 19 is the rights and liabilities of the allotee. So against the promoter or against the allotee, the other party can always approach for violation of any of the duties or obligations by the other party under the act and rules and agreement. There is an appeal provided to the appellate authority both against the RERA decisions as well as by the adjudicating authority. And the Supreme Court in a recent judgment has clarified that so far as the recovery of penalty or interest, etc., is concerned, the powers of the adjudicating authority, notwithstanding the language used therein, has similar, and both have got the power. So we have also discussed earlier, Supreme Court has very clarified that even for violation of the provisions of the act, rules, or under the agreement, the party has got concurrent right, concurrent remedy, either to approach the consumer fora under the Consumer Protection Act, or in respect of or to the adjudicating authority. It is their choice. They can approach even RERA authority under the both acts, whatever remedies are available. And even those, the Supreme Court has also clarified that even in respect of the rights that are conferred under the RERA Act, you can approach the consumer fora, like the section 12, 14 and 18, 19, etc. Next question.
Next question is again by Ms. Shivani. Has there been a PIL put in these states, Telangana specifically, to put the act in a functioning state?
See, the PIL means public interest litigation, which is a technique developed by the Supreme Court and High Courts under the power of judicial review under Article 226 and 32 of the Constitution. This initially, originally this concept was developed by the judiciary for the purpose of only the people who cannot, those disabled people on account of economic, social, or other political disabilities are unable to approach the courts. Any person who is not interested in the subject matter, they can approach they can activate either the Supreme Court or the High Court under that extraordinary power of judicial review. That was the original concept, but it was extended to every activity today. And the original concept of public, the locus standi has also changed for even fundamental rights, for environmental ecology, all these issues. PIL is being encouraged by both the High Court and Supreme Court. So there is no question of any separate law for it is under the Constitution. So it applies to every High Court in the country and also the Supreme Court. Anybody can approach for any public interest, taking up any public cause today. It should be a public cause. And one principle is that you should not have a personal interest, you should have a bona fides in taking up the cause. Now there is a separate procedure you will have to comply with for the purpose of PIL under the rules framed by the High Court. Different High Courts have framed different rules. Next question.
Next question is, there's one last question that I'll take. Mr. Naveen Podar asks, I have recently shifted to a new building. When does the builder transfer the deeds, management and operations to the society? He has collected CAM charges from all the residents last year in April 21 and before. If the builder does not transfer, how can we residents compel him?
You can approach consumer fora immediately. And you can always approach a civil court, but it is a very slow process. Therefore, you can approach the consumer fora, give a notice to him, And if he doesn't transfer that to the society, consumer court can always give a direction. And the keeping that money, he is a trustee so far as that money is concerned. If he doesn't transfer even a temporary it amounts to misappropriation. Even a temporary misappropriation is also misappropriation under the IPC. You can even file a criminal complaint against the builder for temporary misappropriation, also for misappropriation of funds, because he is the trustee for the money. He is holding it in trust for the benefit of the allottees or the purchasers.